Hello, welcome to Legacy Solutions Cyprus. We're here to give you help when it is needed most. Today we're going to be talking about the most common mistakes made when writing a will in Cyprus and giving you some solutions. Let's start with selecting your witnesses. When you write a will, you need to have your signature witnessed, normally by two people, and of course they have to sign on each page. There can, however, be a couple of potential problems with that. First, will they outlive you? And secondly, will they leave the island? If you've chosen a local friend, there's always the chance that they might return to the UK or wherever they come from before their witnessing is required. The reason for that and why that may be a problem is if you've selected local witnesses and something happens to you, those witnesses may be required to appear at the probate registrar to confirm that you had signed the document. The answer to that is to have the will and the witnesses signed and certified by a certifying officer. So there are many local ones, usually including a mukhtar, who, if it's signed in front of him, can stamp to say, yes, this was done, and there's no need then for the witnesses to have to appear at a later date. You can also lodge it at the probate registry. They will do something similar. So your witnesses go along with you to the probate registry. They will then take the will from you and lodge it for future use. The executor next. The executor is the person who's going to carry out your wishes and is normally named in the will. Should it be a lawyer or should it be family or a friend? Lawyers can be executors, of course, but that would mean you have handed them complete control. You therefore need to feel completely at home with that and feel that you can trust your lawyer entirely. If you are not certain of that, then you need to think of alternative arrangements. If the executor is a friend or family, they need to live in Cyprus to do an effective job. They are required to go to probate registrar and sign various documents. And if they can't do that themselves, they'll need to give a power of attorney to a Cyprus lawyer to act on their behalf. That sort of takes you back to the first problem. The executor does have the right to change lawyers should they not want to continue with the lawyer they originally chose, but that is an expensive operation and, of course, creates further delays. Is the executor's role difficult? It is possible that your chosen executor thinks, shall I carry this out myself? It's not uncommon in the UK for this to happen. Here in Cyprus, it is very much more difficult to do. Everything must be completed in Greek, and you're required to register with Ariadne, which is a legal system, in order to log on to iJustice, which is the probate service. So not for the faint-hearted. It does make sense to use someone familiar with the system. Should your will cover Cyprus assets only or everything? A common mistake, again, is to have the Cyprus will cover everything. And as a general rule of thumb, don't do that. Have a separate will in each jurisdiction. The reason for that is that before the Cyprus will could be used to distribute assets that are offshore, it would have to go through grant of probate here. That is not necessarily a very swift process. Courts go on holiday, lawyers take their time, and it can be months before the grant of probate is actually issued. Additionally, all worldwide assets might need to be listed in the probate application and separately accounted for. When a will is taken to the probate registrar, you list the items that it covers. And if that goes on and has various jurisdictions involved, then they're all going to need to be itemized. Of course, this adds a level of complication that is not necessarily useful. It's possible to use the jurisdiction of another country rather than Cyprus rules under Brussels 4. Does that benefit you? Well, yes, it can avoid Cyprus forced heirship rules if these rules don't satisfactorily meet your needs. Drawbacks to this, a potential drawback for a UK citizen is that HMRC may consider you to be UK domiciled, and that would mean you're subject to UK inheritance tax on your worldwide estate. Also, if you've elected to have, say, Italian law apply because you're from Italy or Scottish law because you're from Scotland, it may be that the Cyprus lawyer does not feel confident of his knowledge of those jurisdictions and therefore has to employ an external lawyer, which will, needless to say, add to costs. So what are the forced heirship rules in Cyprus? Briefly, assets are divided between spouse and children, regardless of the wishes expressed in the will, with a percentage that can be allocated by the settlor. If there is no spouse or children, then usually the instruction of the will can be followed in its entirety. Please see our separate presentation for greater details. Remember, a will is fundamentally a safety net, and like most safety nets, it can be full of holes. You want to have one in case something sudden and shocking happens. They're very useful should both husband and wife die very quickly, one after another. But using it does leave your beneficiaries with many headaches, usually at the worst possible time, of course. And don't forget, a will can be challenged as it is a public process. Ideally, you arrange your affairs so that the will is not needed. There are many ways in which you can do this, and this is the area in which we offer specific guidance. You can use gifting, joint ownership, trusts, beneficiary nominations, various other devices that ensure probate and a will are unnecessary. To do any of those things, you have to deal with your affairs now. You don't leave it for someone else to sort out after you've passed. For more information, and of course, if you have any questions, please feel free to contact us. Our website is legacysolutionscyprus.com. I look forward to hearing from you.